not sure if anyone is new.
We have a hand up, Tony from
Oh,
East
there
Hartford.
we go. Hi, Tony. Welcome. I'm
Hello,
clicking
thank you for
between
having me.
screens. Sorry. Nice to have you join us. So
We've
welcome.
got a few others too. I think Arlene and I see someone else waving. So Arlene, if you want to introduce yourself too.
What do you want to know about me?
Just
Bolton Planning and Zoning.
Bolton, welcome.
Yes, and Diane D'Annunzio also. I see her waving.
And Sandy, it
this
looks
is
like you're
Kathy.
waving too over here. You got to take yourself off mute, Sandy.
Sorry.
That's okay.
I've been to a couple meetings, but I am the alternate from Canton, and I don't think I've ever introduced myself. So, welcome to everyone.
Well, thanks. Nice to formally meet you. Anyone else? Or did we get everyone? I think we got everybody.
There we go.
There
we
you go.
It's me, Diane D'Annunzio from Bolton, and I'm on Inland Wetlands and Planning and Zoning.
Welcome.
Thank you.
A Boltonite. Oh my goodness. I used to live in Bolton
Oh, it's a great town.
on Bayberry Road near the Rose Farm.
Mike,
Yes, I know exactly where
my
that is.
neighborhood. Yeah.
Is that
I'm
right?
off a notch. I'm off a notch on Wall Street. It's a cul-de-sac. There's only 4 people on the street.
All right. Well, we
right.
have.
Jen, real quick, I'm just going to share the slides. And I think the next item for you guys.
It's going to be adoption of the minutes from June
Exactly.
5th.
Let me just from current slide. Is that showing up right?
We see you.
You see me?
Yeah, it's not
Oh.
sharing right now.
Hold on. Give me one second.
It might be lagging.
Did it work? Is it working?
It's saying you're sharing, it's just not showing
Ah,
yet.
here we go.
Okay, good. Sorry, my computer's been so slow this week, but all yours, Jen.
Okay, so we have the minutes before us. Any questions or comments about the minutes? And if not, would someone like to make a motion to adopt the minutes as written?
So move to Manning, Bolton.
And
Second.
do I hear a second?
Second, Bizzano, Hartford.
All right. We have a first and a second motion. All those in favor signify by saying aye.
Aye.
Any opposed? Any abstentions? Okay, so the minutes are passed. Moving on to item number 3. We have a presentation from Mike Zizka, Counsel at Halloran Sage, Land Use Case Law Update. And this is also eligible. We're eligible for 1 hour of land use commissioner training. Welcome, Mike.
Well, thank you.
Caitlin, if you wanted to go further into introductions, if I
Yeah,
know you
I don't
had
have
one real
that.
quick.
Yeah, I don't have that much more to add. Again, just want to personally welcome back Mike Zizka to RPC. It's been a few years, but I think some of you may remember Mike from prior land use law updates where we've brought him in and he's provided to our group before. And if anyone can make a solid hour of land use law updates interesting and engaging, I think it's Mike. So again, as sort of was already stated, Mike's a lawyer at Halloran Sage here in Hartford. He's got over 40 years of experience, I think that's right, and his focus on issues related to government agencies, often municipalities, and on the use and development of land. And for those of you who have had the opportunity to take advantage of the Land Use Academy trainings that are often hosted at Wesleyan, you might be familiar with his written work. It's called I think you've got a couple, but the one that makes the rounds is called What's Legally Required, a Guide to Legal Rules for Making Land Use Decisions in the State of Connecticut. And it's now in its 8th edition. And so it's a great resource and highly recommend if you want to really dive into it. So without further ado, again, I think we're really lucky to have you with us tonight. And I really appreciate your time and willingness to do this. So thank you. And I'll turn it over to you, Mike.
Okay, well, thanks very much. First of all, I wanted to say one of the most important things that's not on my resume is I used to be in a club called Bo Marco with Tom Manning. So, Tom, Kathy and I were just talking about that tonight, wondering how many Bo Marco folks were still around. And there you are. So good to see you again. Anyway, okay, I will go into my presentation. Let me do a screen share. And here we are. Let me get rid of that. Come on, there we go. All right. So actually, I noticed that on your slide, you indicated that I was going to go back to 2023. I probably will I'm only going to go back to 2024, I think, assuming that 2023 may be 2024 may be old news to a lot of people, but 2023 is more likely to be old news. So let me focus on 2025 and 2024. And we'll see if, again, I like to have questions from people that have specific issues that they want to talk about, and I'm willing to go pretty much anywhere in the land use area. So if there are specific items that you'd want to chat about that may go back before 2025 or 2024, we can certainly get into those. But let's go through these tonight and see how we do. All right, so the major public land use acts, ironically, the legislature, which is pretty well known for tinkering greatly with land use statutes every year, didn't do a lot of tinkering other than on the housing bill this year. And as you probably all know, the housing bill was ultimately vetoed by the governor. So there was really only one piece of legislation, one public act that came out in 2025 that dealt with land use in any particularity, and that was Public Act 25-33. So we have that and Public Act 25-49, which of course is the vetoed bill. We're going to talk about that tonight. We're going to talk about it because it's obviously going to come back in some shape or form. So I thought it would be worth talking tonight about some of the issues that were probably responsible for the governor's veto. I can't get into the governor's head, but I know that some of the issues that a lot of the municipalities I represent were concerned about. So I want to talk about those because I expect those to come back in some form, and I want people to be sort of ready for them when they do come back. Now, in 2024, there was really, again, only one public act that dealt to any great extent with land use statutes, and that was Public Act 24-143, and that had kind of a laundry list of items that it went through. Again, nothing that made too much of a significant change, but we'll at least talk about those and make sure that everybody is aware of them. So we're going to start with Public Act 25-33. Now, mostly what this was involved with was climate change and coastal planning. So for people from the CROG jurisdiction, the coastal planning aspect of it obviously isn't going to mean a lot to you. So I'm not going to touch on those in any great detail, but I wanted you to be aware of them. By the way, the Public Act doesn't only address land use, it has a number of other provisions that are outside of the land use regulation arena, but still deal with climate change to some extent. So Section 5 and 6 of the Act both modify Section 22A-109 of the Connecticut General Statutes, which deals with coastal site plan review. Section 5 removes the ability of coastal municipalities to exempt the construction of certain individual single-family residential structures from coastal site plan review. And Section 6 was revised to provide that certain site plans that are submitted for different types of coastal site plan review activities have to be referred to the Commissioner of Energy and Environmental Protection, and it now includes the Zoning Board of Appeals in that catch-all category. So again, I wanted you to at least be aware of those. I know that they're not affecting your municipalities. The next provisions will, so let's go into those. The key act, some of the key provisions of 2533, Section 11 is one of the important ones, and it deals with plans of conservation and development. Generally speaking, it modifies Section 8-23 of the general statutes, which is the basic plan of conservation and development statute, and requires that on and after October 1st of 2027, so we have a 2-year window to get ready for this, plans of conservation and development have to consider the impacts of climate change, assessing vulnerabilities, and recommending mitigative techniques. So what I've done here is to list on the right the sections of the statutes that are new. And you will get to see the kinds of things that are now supposed to be in plans of conservation and development. Now, I say that, I won't say it with tongue in cheek, but I will say it you have to take this with a grain of salt, because there really aren't very many hammer type tools that the state can use if you don't prepare a plan of conservation and development the way they tell you to in the statutes. So you've got a number of new provisions saying that you shall do the following things in your plan of conservation and development, but there's really nothing in the way of a penalty if you don't do it or if you don't do it right. I don't know whether any other kinds of penalties will be forthcoming. There have been a number of discussions in the state legislature about, are we going to provide some kind of a hammer to make municipalities do the things that we want them to do? But generally, those have focused on the affordable housing statutes and not so much on plans of conservation and development. So again, I think these are important because you're planners. You're as CROG, as municipalities of CROG, you're supposed to be planning. So these should be important to you. And recognizing the distinction between the shalls and the mays should be important to you as well. But again, I have to take that with a grain of salt because there really isn't any kind of penalty provision that's built in. So on and after October 27, the plan shall include a climate change vulnerability assessment based on information from considerations described in subsection D of that section. I'll let you can always go to the state legislature's website and download these things, but I wanted you at least just to have the new things available to you. So an assessment of existing and anticipated threats to and vulnerabilities of the municipality that are associated with natural disasters, hazards, and climate change, including but not limited to increased temperatures, drought, flooding, wildfire, storm damage, and sea level rise, saltwater intrusion, etc. How do you go about doing this? Well, obviously, that's going to be up to each municipality, just how in depth they want to get into it. And I'm sure there are going to be all types of differences among municipalities as to how they're going to get ready to do it. But I think this is an area where CROG can be a leader in developing strategies for communities to prepare these kinds of assessments, these vulnerability assessments. And maybe providing the tools and the resources for them to be able to decide how to go about doing these things. How do we assess what the increased possibilities are of drought or flooding or wildfire or storm damage? How do we go about assessing what impacts they may have on individuals, communities, institutions, and so forth? How do we go about identifying policies and techniques to avoid or reduce such threats? I think this is where CROG can be a leader, and I'm hoping will be a leader in developing the tools for municipalities to comply with these new requirements. Requirements in quotation marks, again, because there are no penalties if you don't do this. Any such plan of conservation and development shall recommend the most desirable use of land within a municipality. This is what's already in there, but what they've added is include a map showing such proposed land uses, which considers the threats, vulnerabilities, and impacts identified in the climate change vulnerability assessment. That's a little puzzling to me. I don't know how you include a map showing the things that considers, how you prove you considered those things. So I think that's more in there as a reminder. By the way, when you're preparing this map, we want you to be thinking about this. I don't think there's going to have to be anything in the map that singles those things out, but it's just a reminder that when you're preparing the map, please be considering climate change and the impacts of that. E2G, note any inconsistencies with the following growth management principles. And again, that is based again on this concept of climate change and vulnerabilities. You're supposed to determine how that new vulnerability assessment will affect any of those growth management principles. Any such plan of conservation shall identify infrastructure that is critical for evacuation purposes and sustaining quality of life during a natural disaster. I think that's really important. Transportation into and out of places that are subject to hazards. And we know just from the wildfires that occurred in Connecticut over the last couple of years, we know that Connecticut is subject to that. We know from the floods in Oxford this past year that Connecticut municipalities are subject to these things. It's not just coastal, it's not just Louisiana and the states to the south that are facing hurricanes. It's us too, facing similar types of storms. Identify strategies and design standards that may be implemented to avoid or reduce risks associated with natural disasters, et cetera. And interestingly, include geospatial data utilized in preparing such plan, or that is necessary to convey information in such plan. Again, this is where I think CROG can be a leader in helping municipalities deal with these tools. Now we get to the mays. Any such plan may identify one or more areas that are vulnerable to the impacts of climate change for the purpose of prioritizing funding for infrastructure needs and resiliency planning. Now, this is one of the areas where I'm thinking that there may be a soft hammer. This is may be one of the areas where the state says, well, you know what? You didn't really do your plan of conservation and development properly. We don't see that you've identified these areas or explained why you think they're vulnerable. So to the extent that the state has funding, discretionary funding available to provide assistance to municipalities with preparing for climate change impacts, those discretionary funds may go to the communities that did their plans of conservation and development right. So one of the soft hammers again. The commission or any special committee may utilize information and data from any natural hazard mitigation plan, et cetera, in the preparation of such plan and conservation and development, including a document coordinated by the applicable regional council of governments. There you are, folks. You're in there. Such plan may show the commission's and/or special committee's recommendation for a land use program that will promote the reduction and avoidance of risks, etc. A program for the transfer of development rights. That's a sort of a newer thing that we're going to be talking about briefly. Identification of resiliency improvement districts, etc. So there are a lot of tools that are being suggested in this new legislation that you can adopt or make use of in connection with your vulnerability assessments and climate change analyses. All right. Moving on, I changed the color a little bit of the screen so you'll know we're moving into a new area. So that was all of the plan of conservation and development stuff. So now we're going to talk about how it modifies 8-2. So I wanted a color change to emphasize that new area. Zoning regulations adopted pursuant to subsection A shall provide that proper provisions be made to mitigate and avoid potential negative impacts due to public health, public welfare, and the environment due to sea level change in consideration of the most recent sea level change scenario updated. Again, so that is probably not going to affect CROG communities. There's not going to be much impact to CROG communities from sea level change, although arguably to the extent that the tidal bore from in the Connecticut River extends up into the Hartford area, I suppose a sea level rise and the impacts of an increased tidal bore could theoretically cause additional flooding on CROG communities. It's certainly a possibility. And zoning regulations adopted pursuant to subsection A may provide for incentives for developers who use solar and other renewable forms of energy, combined heat and power, water conservation, energy conservation techniques, flood risk reduction building methods. Here's an opportunity for communities, again, to be leaders in providing incentives for developers to take climate change seriously, to take energy needs seriously, and to give them incentives, maybe by giving them increased densities or something like that, to encourage them to take part in this process. Provide for a municipal or regional system for the creation of development rights and the permanent transfer of such development rights. Now, regional system is new, as you'll see, as you see here. All of the underlined parts are new language in the statute in 8-2. So regional was added, a regional system for the creation of development rights and the transfer of such development rights. Subsection C is amended to say that zoning regulations may provide for sending and receiving sites in conjunction with any transfer of development rights established pursuant to section 8-2E. As amended, 8-2E is coming up. Here are the definitions. Receiving site, just one or more designated sites to which development rights may be transferred. Sending site is where they're coming from. Duh. Okay, so that's pretty easy. All right, 8-2E is repealed and the following is substituted. Any two or more municipalities which have adopted the provisions of this chapter or which are exercising zoning power may execute an agreement providing for a system of development rights and the transfer of development rights across the boundaries of the municipalities which are parties to the agreement. This is not obviously related to climate change per se, but this may be the legislature's way of providing additional opportunities for municipalities to meet affordable housing goals, among other things. Transfers of development rights, there may be opportunities for municipalities to get credits for the types of rights that they transfer. I'm not sure how this will all work out, but it's something. It says such agreement may provide that such system be administered by a regional council of governments or other agency. So I think there's an opportunity for CROG here again to be a leader in this concept of transfer of development rights among municipalities. 8-2E continues, subsection B tells you the things that the subsection A, it tells you things that the transfer of development rights agreement can do. I'm not going to go into those in any detail. I just want you to be aware that they're there because it's very technical. So again, just to make sure that you're aware that they're there, you can always go to the public acts themselves on the legislature's website and get a copy of this to review it in more detail. And the same thing with these. This additional modifications of section 8-2E talks about the eligible, it has what eligible sending sites may include but are not limited to. So it's giving you an idea of the kinds of things that the legislature was concerned about. All right, Public Act 25-49. What went wrong? What happened? Why was it vetoed? Again, I can't get into the governor's head, but let's talk about some of the most important provisions that were in 25-49 and which may have been reasons why some of the municipalities were balking and why the governor ultimately agreed with those municipalities that maybe this is too much too soon. It would have amended section 8-2 to require zoning regulations to allow for the as-of-right development of a middle housing development as defined in section 19 of this act on any lot that is zoned for commercial use, with certain exceptions. Section 19 defined middle housing development as a residential building containing not less than 2 dwelling units, but not more than 9 such units, including but not limited to townhomes, duplexes, triplexes, perfect sixes, and cottage clusters. Most of those, again, already being defined in the statutes now. the concept of requiring zoning regulations to allow certain types of residential development remains controversial in Connecticut. The home rule instinct is still very, very strong throughout much of Connecticut, particularly in the more rural areas where they're not used to heavier development. So this is another, I think this is another key feature for them. Okay, here's the state telling us that we have no choice but to allow the development of this type of housing in lots that are zoned for commercial use. Many of the rural towns don't have a lot of property that's zoned for commercial use. Many rural towns have most of their property zoned for residential development, very, very small areas near the centers of the communities, the village centers, if you will, zoned commercially. So I think some of them may have looked at this and said, whoa, you're going to take away our commercial zoning and allow it to be used instead for multifamily type housing. I think that might have been a problem for a lot of rural communities. Doesn't sound so bad when you first read it, but if you think about rural communities and how they've developed and where their commercial property is, you can maybe understand why this might have caused a lot of them to kick up a fuss. It would have prohibited any zoning or planning agency or official from rejecting an application solely on the basis that such development fails to conform with any requirement for off-street parking, unless such officer or commission finds that a lack of such parking will have a specific adverse impact on public health and safety. Now, again, parking has been a huge issue for a lot of towns. And again, I think it may be more critical or at least in the minds of people in more rural communities. I think what they're thinking of is they don't have, in some of the rural communities, they don't have well-developed road systems. They have, well, I shouldn't put it that way. They have good road systems, but the roads may be narrow. They may not have shoulders. They may be really windy and curvy. They may be, and so I think what a lot of these communities may be worried about is when we get big developments and we don't have sufficient on-site parking, we're going to have people parking along these narrow, curvy roads where the sight lines aren't good and traffic tends to speed because it's generally low-density communities out there. And this could be a real safety threat. And yet, despite that last clause in that provision, unless the officer or commission finds that a lack of such parking will have a specific adverse impact on public health and safety. Generally speaking, although this has been more for affordable housing appeals than anything else, when courts are looking at an administrative record, when there's a zoning appeal, and the courts are looking at an administrative record on whether there's sufficient evidence in the record for a commission to have justified its concern about a public health and safety issue. I would say about 4 times out of 5, the court will say there's not enough evidence, that it's just concerns, it's just suppositions. There's no solid evidence. There's no solid evidence showing that there's a real factual basis for a public health or safety concerns. And again, in affordable housing appeals, 4 out of 5 times the courts will say something like that. And in many of those instances, it may even be 9 out of 10. In many of those instances, the courts will say, well, they may have a valid reason for concern, but the evidence is just not there. So I think when zoning or planning officials look at something like that, they think, yeah, that sounds good, but it's not going to work in practice because it hasn't been working in the courts to date. And we know, from the affordable housing decisions that the courts are very, very sensitive to affordable housing and want to promote the state policy to move it forward. So again, I think parking was a huge issue, maybe bigger than a lot of planners thought it would be. A lot of people behind this bill thought it would be. Amended 823B regarding a zoning amendment protest as follows. I'm sorry, that's a typo. That should be 83B. I apologize for that. Anyway, that should be 8.3b. Amended 8.3b regarding the zoning amendment protest as follows. If a protest against a proposed change is filed at or before a hearing with the zoning commission, signed by the owners of now 50% or more of the area of the lots included in such change, or 50% or more of the owners of lots included in such area, or 50% or more of the lots within 500 feet, such change shall not be adopted except by a majority vote of all of the members of the commission. So what that would have done is pushed up the standard for a protest vote. You have to have a lot more people protesting the proposed change, and pushed down the threshold for the majority to get around it. To say such change shall not be adopted except by a majority vote of the members of the commission is kind of a joke. I mean, it's really ridiculous if you stop and think of it, because you can't pass a zone change without a majority vote anyway. So to say if you file a protest vote, the majority can't override it except by a majority, the commission can't override it except by a majority vote. Well, that really makes the protest vote meaningless, because there's no new standard for the commission to act. Well, no, I take that back. I take that back. Okay, I'm looking now at a majority vote of all of the members of the commission. So it would do that. In the case of, so without a protest vote, it would mean you'd only need a majority of a quorum, but with a protest vote, you'd need a majority of all of the members of the commission. So I take that back. I apologize. I didn't read that closely enough at first. So that is a little bit of a change, but it's still a weakening overall of the standard. And I think a lot of communities that I have represented in the past really take public input very seriously, maybe too seriously in some instances. Maybe they lean too heavily in favor of people that that have a NIMBY attitude. I can't say that that's not true. But I think a lot of communities may have been worried that this is really kind of diluting the power of people to come in and express their concerns to the commission, especially on a zone change, a zoning amendment, where the commissions may think that the public should have more of a right to be heard because it's much more of a discretionary decision than they would in an administrative type of situation where it's just somebody asking for approval under existing regulations. All right. The Public Act would have required a priority affordable housing plan to be prepared by any municipality identified by the Secretary of Housing to be in the highest 80% of the adjusted equalized grand list per capita, et cetera, et cetera. The priority affordable housing plan would be subject to a number of new state requirements, including they would have to identify specific zones or parcels sufficient to build the municipality's affordable housing allocation as of right, and the planned density for such zones or parcels, detail how the municipality intends to change its zoning regulation and utilize compliance implementation mechanisms, etc., and provide for the creation of a sufficient supply of the different types of affordable housing required for meeting 25% of the municipality's number of affordable housing units allocated to such municipality pursuant to such municipality's affordable housing allocation. Now, the affordable housing allocation, for those of you that are not familiar with those terms, is something that was going to be set by the state for each municipality. There was going to be a number of housing units or a percentage of housing units that each municipality was going to be assigned at some point by state regulators, determining how much affordable housing they should be providing. And this was the beginning of the state saying there are some municipalities that we are going to really force this on. There are some municipalities that we are going to absolutely make do this. And it sounds, from the way it's defined, like it was more down in Fairfield County for the most part, because that's where the highest grand lists are likely to be. Although it could affect many of the wealthier Hartford area communities. I'm thinking of Avon and Simsbury, and I don't know whether or not they would have fallen under that rubric or not. But again, here is the state now saying, okay, towns, if you're one of these towns, You are going to have to do these things. You are going to have to put in regulations that basically guarantee that you're going to have a sufficient supply of affordable housing unit to meet at least 25% of your goal. I think that made a lot of people very, very nervous. So I think that's a big one. Notice the bottom one. Upon state approval of municipalities' priority affordable housing legislation, the municipality would be required to amend its zoning regulation and implement compliance implementation mechanisms in accordance with such approved plan. Now, again, there was talk in this bill about using discretionary funding and establishing priorities on the basis of towns that have done a better job of doing this and not. There wasn't anything yet where the state was actually saying, we are definitely going to give priority to these, and those who haven't done it right are going to get left out in the cold. The state wasn't saying that just yet, but I think a lot of municipalities were saying, okay, here it comes. That's next. And I think that made them very frightened. Prohibited a municipality from installing or constructing hostile architecture in any publicly accessible building or any publicly accessible real property owned by the municipality. And that was defined as any building or structure that is designed or intended primarily for the purpose of preventing a person experiencing homelessness from sitting or lying in the building or on the structure at street level, provided hostile architecture does not include certain design elements. I think the problem with that is, how do you determine whether a building or structure is designed or intended primarily for the purpose of preventing a person experiencing homelessness from sitting or lying in the building? How do you make that determination? You're asking somebody to get in the head of the developer or in the head of municipal planners as to what they were thinking when they came up with this design. They may be thinking, and I really don't mean to be facetious here. They may have been thinking, we're doing this to keep rats out, or we're doing this in case we get, a foot of flooding to prevent, floodwaters from coming in. So how do you make this kind of determination? I don't know. And that may have been a concern to some people. The act would have amended Section 8-30G to allow a court to award attorney's fees if a denial of an affordable housing plan was made in bad faith or to cause undue delay, and the total number of units in the affordable housing development or affordable housing or affordable dwelling units in the set-aside development ordered by the court to be built is at least 90% of the units proposed in the original application. So basically, again, we're throwing a brand new hammer into 830G. I don't think it would be very difficult for a court to find bad faith in some of these situations. There have been a number of affordable housing decisions where the courts have used very, very harsh language on the municipalities. And I know that some of the municipal housing or the affordable housing lawyers often go into communities. I've seen this happen in my communities. They go in and they accuse communities of being discriminatory, which obviously makes teeth grate among those communities that are being told that. And yet, it almost seems in some instances, to me at least, as some affordable housing decisions sort of take that for granted, that there's some inherent discretion going on, maybe because they've heard that from these lawyers so many times, but that there's some inherent discretion that's being abused here, that these communities are really just not trying to comply with the statute. They're just trying everything they can think of to get around the statute. So I don't think it would be very difficult for a court to find bad faith or undue delay. And the attorney's fees involved in these types of cases can be astounding. They can be easily in the six figures. So this, I think, could have been a big concern. required municipalities having more than 15,000 residents to adopt an ordinance creating a fair rent commission. The current threshold is 25,000 residents. So a whole raft of new communities and new municipalities were going to have to create fair rent commissions. Whether that was a concern, a particular concern, I'm not sure. And then again, based priority for certain discretionary state funding to state certification that a municipality has adopted such measures as transit-oriented districts or priority housing development zones. I think municipalities that were not in a position that they think to create such zones, maybe because they don't have any real mass transit in the communities, were concerned about, okay, all state funding is going to go away from our community and go to these communities. And again, I don't know. I can't get into anybody's head, but I think these are issues that were of concern to some communities. Okay, so those are, when I say Public Act 25-49, what went wrong, that's what I'm talking about. I don't know if that's what those things are what went wrong, but I do think that those are issues that a lot of communities that I've been dealing with are very, very concerned about, very, very upset about. And if you have a great number of communities that are all going to the governor and saying, gosh, this is killing us, the governor obviously sat up and took notice at some point. Now, why this didn't come out well before the act was passed into law, I don't know. I'm not sure why the process failed in that respect, because it seems as though these things maybe could have been worked out, maybe they couldn't have been worked out. But in the fall, when if the legislature goes into special session to consider the Affordable Housing Acts again, I think these are all big red flag issues that are going to be waived again. So your community should be aware of them. I don't know how your individual communities feel about these different things, but you should be aware that they were in the bill. If you have concerns about them, you should be ready to go to your legislature and express those concerns, but do it early. Because if pretty much the same bill comes out again, and I don't know that the governor would veto it again. All right, moving on to the one public act in 2024 that had any significant provisions for land use regulation. Section 3, which is now incorporated into Section 8-2R of the general statutes, required zoning regulations to allow certain conversions of nursing homes into multifamily residential structures, subject only to summary review. In other words, site plan review at most. Special permits or special exceptions cannot be required. Now, conversions of nursing homes, I don't know how big of a problem that's going to be. I don't know how many failed nursing homes are out there, or defunct nursing homes are out there, or are likely to be out there in the future. But that is, that's pretty much all this was addressing. But for those communities that have these, obviously, it could be a concern. The conditions are the nursing home must be a freestanding structure. It must not be a non-conforming use. So that might take away a lot of concern. The conversion may not result in the substantial alteration of the footprint of the structure. The conversion may not result in the total demolition of such structure. The owner of the nursing home must have declared that the nursing home has been vacant for a period of not less than 90 days, immediately preceding the submission of the summary review application. So the legislature is hitting the right concerns here. They want to make sure that this is not getting rid of, essentially a way to get rid of nursing homes that may be financially viable, but the developer doesn't want to do them anymore. So, or I shouldn't say the developer, the operator doesn't want to do them anymore. The conversion may not result in the total demolition or result in the substantial alteration of the footprint. We're talking about reuse of the structure. If we're going to have a substantially different structure, then the person who's making the application should go through the process. The idea was, if you're just taking an old defunct structure that may not have any other good use because of the nature of the zoning in the area or whatever, then let it be turned into housing. Let it be turned into multifamily residential. So I think this was a fairly modest bill, not a very far-reaching bill, but it is implemented into law, and that may be one reason why it was implemented, because it is modest. If a conversion application is subject to summary review, the act requires it to be decided within 65 days after receipt, subject to a possible extension of up to another 65 days. Now, this is one of those areas where the legislature just isn't very careful, or doesn't seem to be very careful, because there's a difference between the way they use the word receipt and the phrase date of receipt. When they've used the word date of receipt in section 8-7D, for instance, which sets the timetable for most planning and zoning decisions, date of receipt is defined as relating to the provisions of that particular chapter or that particular section, 8-7D. It doesn't say that whenever the word receipt is used, that it shall mean date of receipt. So when the legislature now says in a different statute, 8-2R, that you have to act upon it within 65 days after receipt, they may mean actual receipt. Or even if they didn't mean that, that's how a court, it seems to me, is likely to interpret it. Because the court might say, well, the legislature knew how to say date of receipt when that's what it meant. And it didn't say that here. So a trap for the wary. Okay. Section 21 added the following new subsections to 8-26A regarding protection of previously approved lots. And you have to take a deep breath when you read either of these because they're a little bit hard to follow. But any vacant lot that is depicted on a subdivision or re-subdivision plan that has been recorded on or before October 1, 2024 in the land records of the municipality in which the lot is located, if the recorded chain of title for such vacant lot references such subdivision or re-subdivision plan, it shall not be required to conform to the lot shall not be required to conform to a change in the zoning regulations or the boundaries of zoning districts in the municipality that is adopted after the approval or recording of the subdivision or re-subdivision plan. So what's the difference here? What happened? What happened is previously 8-26A always required a filed and approved subdivision or re-subdivision plan. If you had a vacant lot on a subdivision plan that had been approved by a planning commission, you were entitled to this grandfathering effect. And a lot of real estate advocates went to their legislators and said, you know what, we've got all of these old subdivisions that have been filed on the land records way back before zoning or way back before subdivision regulations went into effect. And none of these lots are grandfathered now because of that. So let's extend this grandfathering to those lots as well. And so the legislature kind of went along with that and said, okay, we will do that. Now, what's the problem? The problem that I see is in many of the communities that I have seen, especially if you have communities with lakes or whatever, there are a lot of subdivisions that were created back before subdivision and zoning regulations around these lakes. And they have tiny, tiny lots, 50 by 100 lots, 50-foot by 100-foot lots. They're not really suitable for septic systems. They're not, so unless you have sewers in the area, it may not really be feasible to be developing these properties and protecting public health and safety. So I think previously the legislature had been thinking, if we're going to grandfather these lots, we want to make sure that they've at least been vetted by a planning commission at some point in time. And now that vetting provision has been taken away. So all they have to have been done, all that has to have happened is they had to be recorded in the land records. I think that's a bad change, but that's me. So I'm not here to be on a soapbox. I'm just here to tell you what's going on. So that's what's going on, but I got on my soapbox anyway, because I can't help it. All right. Subsection C it's hard to read it as being much different from what subsection B said. But again, it's basically to grandfather lots of record that have been in existence prior to the time that zoning regulations were adopted. So that was, again, one of the major provisions of that 2024 Public Act. All right, now we're going to get on to the cases. Strangely enough, I had found I've been practicing for, oh God, help me, 43 years. Oh my God, 43 years. All right. And what I've seen in that, and I know I only look like I'm 29, right? And what I've seen in that time is since the appellate court was established, the appellate court used to take a lot of zoning cases. They used to really relish zoning cases for some reason, or land use cases. Now they don't so much anymore. The Supreme Court didn't. And I think what was happening in the early days of the appellate court, they were taking most of the planning and zoning cases and wetlands cases. And the Supreme Court, which only had to hear appeals from the appellate court by certification, didn't take very many of them at all. And I think they kind of liked it that way. So the appellate court was doing a lot of this because with the appellate court, you can only get a planning or zoning appeal up to the appellate court by certification. And they used to, so as I said, they used to take a lot, not so much anymore. In the last few years, the appellate court has taken very, very few cases, and very few, I should say, very, very few land use cases. They take a lot of other cases because land use cases have to be certified. Most other cases don't. So they can't help but take all kinds of other cases. But land use cases, they don't have to take if they don't want to. So there have been very, very few of late. So I don't have a lot of decisions to talk about. Interestingly enough, most of the decisions that I have to talk about come from the Supreme Court. And you can imagine if the appellate court doesn't have to take them, then the Supreme Court's never going to get them. So the Supreme Court generally only will take cases that the appellate court has certified anyway, land use cases that the appellate court has certified. So that whittles down the number of land use cases, and then it's whittled down even more for the Supreme Court to take them. So if the appellate court is only taking 3 or 4 cases, that's about all that the Supreme Court has an ability to take, and they're not usually going to do that. So surprisingly, the cases I'm going to talk about mostly come from the Supreme Court. And the reason for that is in 2 of those cases, they reverse the appellate court.
Mike, can I ask a quick question?
Sure, absolutely.
What do you mean by they must be certified? Because I have to
Okay.
admit, I don't know what that means.
Thank you. Thank you for the question. In most instances, when the superior court, the first level of court, renders a decision, there's a right to appeal that decision to the appellate court. With planning and zoning and inland wetland appeals, it doesn't work that way. The state law on that, which is section 8-8, says that the appellate court only has to take an appeal from a planning and zoning decision or wetlands decision by a superior court judge upon certification. What you have to do to gain certification is the person who lost the appeal in the superior court has to file a petition for certification, which can only be 10 pages long, with the appellate court, basically saying, here's what happened, here's what the superior court did, and here are the legal reasons why we think it's wrong. The winning party at the superior court level then files a statement in opposition saying, adding any facts that they think have not been set forth properly or at all by the potential appellant, saying anything else about that they think they need to say about what the superior court judge did, and then explaining why they think what the superior court judge did was just fine. The appellate court then looks at that, and from what I understand, they have conferences where they kick these things around and say, what do you think, folks? Is this an interesting enough case that we want to accept it for appeal? And I think if it's either, I'm not sure if it's 2 or 3 judges now at the appellate court level, but if the right number of judges says, yeah, we think it's interesting enough to listen to an appeal, then it gets certified. And the appellate court will issue a decision saying this case is certified for appeal. The same thing happens when the appellate court makes a decision. The Supreme Court doesn't have to hear it. You have to file a petition for certification to the Supreme Court, and it's the same procedure. 10 pages you get for your petition. The other side gets 10 pages for a statement in opposition. There's no opportunity for a reply in these cases. And if you haven't managed in those 10 pages on either side to convince the court to take the case, it won't take the case. It won't certify the case. If the Supreme Court thinks it's an interesting issue, or that the appellate court got something wrong, then the Supreme Court will certify the case. But again, that has been relatively rare in the planning and zoning area. I'm not sure how frequent it is in other areas, but it's relatively rare in the planning and zoning area, because I think I don't think the Supreme Court is really all that generally interested in that area. Felt the appellate court was doing a good enough job handling those cases. So that's what certification means, Kate. Was that good? Okay. Okay. All right. So here's the first one. I'm going to go in reverse chronological order. The first one was 9 Pettapog LLC versus Planning and Zoning Commission. The facts are the commission adopted, this was the Planning and Zoning Commission of the Borough of Fenwick. For those of you that are not familiar with the Borough of Fenwick, it's a sort of a subset, a geographical subset of the town of Old Saybrook. It's a very, very small land area on a peninsula, basically on a peninsula of the town of Old Saybrook, where it's entirely residential. It's fairly well known for being the site of Katharine Hepburn's former property, but very, very small and, just as I said, entirely residential. So one of the big issues there was short-term rentals. There had been some people in Fenwick who had been doing a lot of short-term rentals, and others who had fairly expensive property in Fenwick that didn't like the fact that there were short-term rentals going on. So they asked the Planning and Zoning Commission to address the issue, and the borough to address the issue. So the Planning and Zoning Commission of the borough adopted zoning regulations that dealt with short-term rentals. One of the neighbors who felt that it was going to be too permissive appealed. Now, the appeal was filed too late for a typical zoning appeal. With a typical zoning appeal where you're challenging what the commission did substantively, you have to file it within 15 days after the notice is published of what the commission did. And the notice of what the commission did has to be published within 15 days of doing it. So what that means essentially is the longest that a neighbor can possibly go to challenge the substance of what a commission did is 30 days after the commission did it. So that's the typical zoning appeal. Most of the time, the notices are properly published, and most of the time, the appeals are properly filed. Well, this neighbor wanted to appeal, but he was too late because he was 2 months after the commission acted. Now, state law, subsection R of section 8-8, allows people to file an appeal within a year if they're challenging a public notice that the commission was supposed to give. Because as you all know, virtually all land use decisions are, well, no, I shouldn't say virtually all, but certainly special permit decisions, site plan decisions, special exception decisions, many wetlands types of decisions, re-subdivision decisions, subdivision decisions, those kinds of things all have to be published. They don't all have to have a hearing, but most of them do. So if they have to have a hearing, you have to publish a notice of the hearing, and then you have to publish a notice of the decision. In all of those cases, the statute says that you have to publish in a notice, the notice in a newspaper, either having a general circulation or a substantial circulation in the affected municipality. In this case, since it was a zoning regulation, the statute said it has to have a substantial circulation in the municipality. Well, Fenwick has published its notices in the Middletown Press. The plaintiff's lawyer went to the Middletown Press and said, how many subscribers do you have in Fenwick? Middletown Press came back and said, none at this time. We have no subscribers. Neighbor said, okay. The borough failed to publish its notice in a newspaper having substantial circulation because if there are no subscribers, it's got no circulation. End of case. The borough said, wait a minute, we've been publishing in the Middletown Press for years, over 20 years. Everybody in the borough, or most people in the borough, know that that's where we publish our legal notices. The legal notices are all available online for free. You can go to the public notice website and you can get these notices for free online. So even if you don't subscribe, you have a way of getting these notices. The Middletown Press is also online. You can subscribe to it online. You can view a lot of it online. So things are changing. Hard copy newspapers aren't as prevalent as they used to be. And so you have to look at that substantial circulation in a different light than it may have been looked at back in the early 1900s when this statute was passed. Well, the Superior Court agreed with the neighbor and said, no subscribers is no circulation, and there's no evidence that the paper was circulating in any other way. We appealed. I was representing the borough. We appealed we sought certification from the appellate court. They granted certification. We made the argument that substantial circulation should not be based solely on circulation figures, that there are other ways to figure it out, and it's supposed to be the appellant's burden to demonstrate a lack of substantial circulation. But the appellate court agreed with the Superior Court. I think that one of the things that the plaintiff was saying to the Superior and Appellate Court judges, look, all of the cases in the past that have decided that a newspaper had substantial circulation focused on subscription numbers. So that's the way they do it. My argument was, in those cases, circulation numbers or subscription numbers were easily available, readily available. And if those numbers in and of themselves were sufficient, the plaintiff didn't, or the commission didn't have to do anything more than show the subscription numbers. But now it's different. You can't just rely on subscription numbers. And the fact that that's what they did in those past cases doesn't mean that's the way you're supposed to do it. Well, the appellate court just went along with the Superior Court and said, we think that you didn't show any subscription numbers and you didn't show anything else, so you haven't proved that the newspaper has substantial circulation. All right, so it goes to the Supreme Court now. The result, the Supreme Court agreed with us and said the question of whether a newspaper has substantial circulation is no longer necessarily going to be based solely on the number of subscribers. That can be a factor, but it's not the only factor. Although actual sales and subscribership may be considered in determining availability, other relevant factors include where and how the newspaper is distributed, the frequency of distribution, the existence of any cost barriers to access, whether the newspaper has been consistently used for such notices and for how long, and whether residents are aware of its use for the publication of legal notices. So because we had provided evidence that the newspaper had been used for over 20 years and that most residents knew of it and that it was available, the notices at least were available at no cost, and it was a daily newspaper, the Supreme Court sided with us. So that has created a new paradigm for determining whether the newspaper that you use is a newspaper of substantial circulation. Now, for those of you that are using the Hartford Courant, you may think, well, that's not going to be important for us. But on the other hand, what we found in Fenwick was even the Hartford Courant didn't have much of any subscribers. There, at the time that I think at the time that the plaintiff asked the Hartford Courant how many subscribers they had, and this was so they could show the court, see, there are other newspapers they could have used. I think that the Courant said they either had 3 or 4 subscribers, and 3 of them had subscribed only because the Courant had given them like 3 months for a penny or something like that. And that there was no indication that they were going to continue subscribing when the subscribing cost went back up again. So, I mean, basically, even the Courant was saying, we don't have much of any subscribership down there anyway. And so the thing is, if not a sufficient number of people are subscribing to even the Courant, what newspaper are people going to use? How do you figure out what to use if subscribership is the key? And I think that's what the Supreme Court had in mind. As the subscribership goes down because people have so many choices to get their news, it doesn't make any sense to focus on subscribership. So that was a fairly, I won't say it was a change in the law, because there hadn't been any cases that really established what newspaper of substantial circulation meant. But it does set a new paradigm for what it means. Next case, 131 Beach Road LLC. Oh, I've got another typo in there. It's not LLC versus Town Planning and Zoning Commission, 349 Connecticut 647. The plaintiff applied under Section 830G, the Affordable Housing Appeals Act, for a change in zoning regulations to allow development of affordable multifamily homes in a zoning district and to approve a specific affordable housing development proposal. Now, the way they had asked for the change in zoning regulations was they looked at the district that the proposed affordable housing property was in, and they said, okay, it's the A district. We want to change the regulations for the A district to allow affordable housing. And then they submitted their affordable housing plan. So the commission denied the change in regulations based partly on its proposed application beyond the parcel at issue. They said, you really don't need to change the zoning for all of these other properties in order to get what you want. In fact, you don't even have to change the zoning for your own property to get what you want, because the Affordable Housing Appeals Act itself takes care of that. But they approved the development plan. However, there was a condition that the height be lowered from 60 feet to some other level, I think by a full floor, based on the commission's concern with the building's visibility from a nearby historic district. And the commission had people that had come in to testify at the hearing on this, that the property was easily visible from the historic district, that there was nothing like property of this height in the area, and that it would really change sort of the feel of the historic district. Because when you're looking at this 60-foot tall building not far away, you don't feel like you're in a historic district anymore. That's so I'm not standing behind that, or well, I'm just telling you that's the argument. Well, the plaintiff, not surprisingly, said, well, look, the zone change is entirely governed by 830G, because it's accompanying a specific affordable housing proposal. And the impact, there was nothing to show that whatever impact that was supposedly going to happen to the historic district because of the building's height, there was no proof that it outweighed the need for affordable housing. And the plaintiff noted that if you reduce the height of the building, you're going to reduce the number of affordable units that are going to be made available. So those were the competing claims. Here's what the court did. The court said, it's not obvious to us that any substantial interests in historic preservation are implemented in this case. And even if they are, the commission has not met its burden of demonstrating that its imposition of the height restriction as a condition of approval was necessary to protect a public interest that clearly outweighed the need for affordable housing in Fairfield. there are a number of factors that went into that decision, and they're all important to those communities that are facing an affordable housing appeal. One of them is the substantial evidence test. If you're going to claim that there is a substantial impact on something of value, you have to do more than say it. You have to do more than assume it. You have to show what it's going to be, what that impact is going to be. Now, I think the commission, in its defense, thought it had done that. It had brought in some experts who analyzed it and said, because there is nothing in this area that's even anything similar to a 60-foot tall building. This is a dramatic change. And so now the viewscape is really affected by that. But I think the court was looking at that and saying, okay, the viewscape was affected, but how do you measure that impact? How do you put a number on that? I mean, is that the kind of thing where somebody looks at that and says, oh, gee, that's unfortunate, and then forgets about it, and then starts looking around at the historic district and paying attention to the historic district? I mean, so yeah, there's an impact, but is it really substantial? How do you measure that? What do you do to measure that? And there was no, not surprisingly, I guess, but there was no real evidence about why that was considered to be important. Maybe what the court was looking for is there evidence that something like this has happened in other communities and that it's diminished the interest in the historic district in that area? Is there something similar that you can point to where there was a tangible impact on the historic district itself? And because the court said there's not enough evidence of that, it couldn't find the commission's decision convincing. And don't forget, they have the burden of proof on an affordable housing appeal. Likewise, it said, and even if there is an impact, you have to approve that preventing that impact outweighs the need for affordable housing. And the commission didn't do anything to demonstrate that, didn't give any real justification as to why that kind of impact would outweigh the need for affordable housing. And the court noted that Fairfield had less than 3% of the types of units that are considered affordable housing under 8-30G. The court also noted that the property is within 500 feet of 80 plus commercial businesses, including a gas station and a 3-story medical office building. And the court said that undermines the defendant's assertion that the height restriction is necessary to protect a substantial public interest in the historic preservation of buildings located in a different district. And that actually makes sense not only in the affordable housing context, but also in other contexts as well. Because theoretically, I mean, if you were in a zoning district where a particular type of development was allowed, specifically allowed, you don't want a commission to be able to say, well, it's specifically allowed by our regulations, but we think it's going to have an impact in another area, and therefore we're going to deny you. So I can understand the court's reasoning here. But again, the most important thing is lack of evidence. And it shows the high standard that the courts look for in terms of evidence when a commission is trying to deny an affordable housing application.
Hey, Mike,
right.
real
Yes.
quick, just to keep in mind, we have about 15 minutes for both the presentation and the Q&A. So
Okay.
keep that in mind as you go ahead.
All right. I will, I'll wrap up then, try to wrap up real quick. All right. Also, the statutory scheme created to safeguard the public interest in historic preservation, the historic preservation statutes contain no indication that it includes consideration of the visibility from the historic district of other properties. Lastly, the court said, we agree with the commission that the affordable housing statute doesn't extend to zone changes outside of the affordable housing property. So the change to the zone had to be limited to the affordable housing property. So those are the important decisions from that. All right, Wiebe versus Zoning Board of Appeals. Plaintiff was ordered to deny by the CEO to cease and desist from renting property to guests on a short-term basis. Big issue in Connecticut communities, short-term rentals. Zoning Commission in 2018 amended its regulations to prohibit the rental of single-family dwelling for less than 30 days. Plaintiff claimed that his use of the property was grandfathered because it had been permitted under the 1994 regulations. Commission said no, it wasn't, because in 1994 we allowed single-family dwellings or residences, and short-term rentals are not residential by their very nature. They're just not residential. They're not single-family uses. Court says, we agree with the plaintiff. Nothing in the term dwelling or residence necessitates a finding that a house be used as such for any particular length of time. So if you say single-family use or residential use, if you don't specify what timetable you're talking about that, there's no way to distinguish a 2-week rental from a 2-year rental. The court said in that length of time, the same kind of uses could be going on. And if they're residential uses, they're residential uses. The court went further with that. Building designed for and occupied exclusively as a home or residence, that statement or that phrase is ambiguous and reasonably can be interpreted as permitting the erection of houses or dwellings designed for occupation for any given time without any temporal occupation requirement. The court also noted the appellate court's observation that the ability to rent property is 1/3 of an owner's bundle of economically productive rights constituting ownership, and the intent to deprive landowners of that right cannot be assumed in the absence of clear language evincing such intent. The court held zoning regulations must be strictly construed and not extended by implication, and a zoning regulation that is susceptible to multiple reasonable interpretations will be construed in favor of the landowner. Nevertheless, the court said zoning authorities are free to adopt regulations that permit only long-term rentals in an effort to promote stability and a sense of community within a single-family residential zone. So what they're saying is you can do it, but you've got to be very, very clear about what a short-term rental is and what it is you're forbidding. Now, what the appellate court said, I think, is also important, because the appellate court, the Supreme Court left open the question of whether a community could actually prevent somebody from renting single-family property. And I think the appellate court is saying, wait a minute, to prohibit all rentals of single-family property, even if they're rentals for a year or rentals for 2 years, we don't think you can do that. I think the appellate court was hinting at that. The Supreme Court didn't touch that issue, but I think that's one to be aware of. Don't take this decision too far. It says you can regulate short-term rentals, but I don't think you should read this far enough to say you can regulate rentals, period. All right, High Watch Recovery Center. This was a case involving whether a change in a non-conforming use was an extension or expansion. The commission approved a special permit in 2008 for a plaintiff to conduct therapeutic uses, including what he called therapeutic agriculture, or what the center called therapeutic agriculture. The zoning regulations were subsequently amended to disallow all clinical uses in the zone. The site had been an active farm prior to the plaintiff's purchase. The plaintiff later sought a special permit to establish a new greenhouse to allow it to conduct agricultural uses throughout the year. The new use was not specifically designed for therapy, but to increase plaintiff's food production to service its main clinical facility on a nearby parcel. Plaintiff claimed that the proposed new use was merely an intensification of its existing non-conforming use. Commission denied the application as an improper expansion of the non-conforming use. Now, here's what the court said. First of all, the Superior Court agreed with the plaintiff. No, I'm sorry. I take that back. I should know this. It's my case. The Superior Court agreed with us that it was an expansion of a non-conforming use. And the court said, number one, you got a special permit. Kent's special permit regulations require you to show all of the buildings that you want approved. This greenhouse was never shown, so it's not within the special permit. Therefore, it's not something that can be added because that would violate special permit criteria. It also said you're changing from a seasonal use to a year-round use. That's not allowed under current case law. The plaintiff came in and said, "Oh, no, there's a case that was decided, I think back in around 2000 or 2001, or maybe even earlier than that, called Zaks versus Zoning Board of Appeals, where the Supreme Court set out a three-part test for whether something is an expansion or an extension or an intensification, which is allowable. And this is just an intensification under those standards. The Supreme Court said it's an improper expansion because it would extend the non-conforming agricultural use from seasonal to year-round. In past cases, the court had consistently held that changes of non-conforming uses from seasonal to year-round were significant changes of the character of the use and therefore impermissible in the absence of more permissive regulations. It's important to understand that commissions don't have to be this restrictive, but they can. The court also held that where a property has several non-conforming uses, changes to each must be examined separately. So the court said they may have been conducting other uses, other types of therapeutic uses on a year-round basis, but they weren't conducting agricultural therapy on a year-round basis. So that has to be examined separately. The court also noted that the special permit the commission had granted limited the plaintiff's use of the property to what the plaintiff had requested at that time, and that request had not included anything other than an outdoor agricultural therapy program. So it went beyond the scope of the special permit. The court didn't specifically note the fact that the building hadn't been shown on the approved special permit plan, but it did sort of go along with that idea that the special permit that had been issued controlled what you could consider an expansion versus an intensification of the non-conforming use. So a very important case on the subject of non-conforming uses. Town of Greenwich versus Freedom of Information Commission. Basically, what that case is saying is the town cannot assert an exemption under the Freedom of Information statutes without actually examining the records that they're claiming are exempt. It was a situation where the town had a computer system that had been modified over time, and there had been various iterations of documents that had gone forward through time in that computer system. And the commission wanted to say, well, those are all drafts. Those were all drafts. Those are all preliminary documents. So there was no need for us to show them. And the court said, you can't say they're all preliminary documents without actually looking at them, which is what the commission had done. And also it said, even if you had determined that they were preliminary documents, the statute also requires you to determine that the public interest in withholding the documents clearly outweighs the public interest in disclosure. And no such analysis had been made. So again, an important Freedom of Information case. The Freedom of Information Commission is very, very strict on withholding documents, and they're going to put you to your proof. So there's a case about that. Inevitable caveats. These slides are intended for educational and informational purposes only. Readers are advised to seek appropriate professional consultation before acting on any matters discussed in this presentation. And these slides may be considered attorney advertising. I don't mean them as such, but they could certainly be construed that way. That's all I have. So you've got, oh, I'm sorry, you got some time anyway. Be glad to take any questions.
Yeah, we got about 5 minutes. Thank you so much for the presentation. That was incredibly informative. I already have questions asking for it to be shared. So I'll send them around tomorrow. And again, next week, but they'll be posted on the website otherwise. Anyone have any questions?
See, that's why I didn't want to rush too fast through it.
Hey, no worries. Looks like you're just getting praise. Everyone's
God.
clapping.
And
All
I've
right.
got one
People
or, I've
have
got
done-
one or two if no one else does, but I want to
Oh,
make sure
good.
to give.
Okay.
Is there somebody else? Anybody? Okay. Super quick. I just wanted to confirm on the subscribers, like when I think of like the totality of the area that the Hartford Current serves, when you're looking at this, it is the subscriber specific to the municipality in question.
That's
Okay.
correct.
That's,
Yes.
I was wondering and then assumed that.
Yep.
And then it was interesting to me for 131 Beach Road. It sounded, it was interesting. You were presenting on that, and I was thinking about earlier, you know, when you were speaking of the potentials of House Bill 5002, I forget all Public Act 2544 that didn't get approved.
Right.
You're thinking about that the appeals system, but that was no, that would have applied. No,
I
I'm
think,
thinking of the 830G appeals, and is that the you see that I'm like not threading this question correctly. But it made me think, were those two related? Was the impetus maybe for some of that being able to appeal for legal fees potentially coming out of the case like 131 Beach Road?
I don't think 131 Beach Road itself was the kind of case that that concern might have specifically come out of. I think municipalities are concerned more generally that the legislature at some point will just be, getting so jaded with the fact that municipalities are not moving fast enough to implement some affordable housing provisions, that it's not growing the affordable housing in the state enough, that they'll start putting the hammer down by saying, okay, we're going to let any successful appellant on an 830G get their attorney's fees. Any successful appellant. I think they're certainly concerned about that. And so in this case, the legislature was saying, okay, there's got to be a finding of bad faith. So they were trying to say, okay, well, we won't let them collect on anything, but if there's bad faith or an attempt to delay, then we will do that. But I think municipalities always see that as the camel's nose under the tent. And they say that's not going to be the end of it. And also, as I said, it wouldn't be that hard, I think, for many affordable housing judges to find bad faith. Or an attempt to delay in what these commissions are doing. Because if the courts are essentially saying, you're using fears and suppositions to deny this, so you really don't have any good basis for do this. That's not very far from saying you're acting in bad faith. So I think it certainly it wasn't the Beach Road case specifically, but the number of cases that have preceded that, where courts have really excoriated towns for how they've handled an 830G application, that worried the towns.
Thank you.
All right.
Anything else, Caitlin? Oh.
Anyone else have any questions? I think we can take one more, Caitlin or Jen, and if not, we can get back to regular business. Going once, going twice. All right. With that, thank you so much, Mike. I appreciate it. I'll be in touch.
What do you want me to do about those typos?
Hey, don't worry about it.
Okay.
If you want to fix them and then send me the slides,
Okay.
that totally works. But I'll be in touch probably some point tomorrow morning, and we can talk about it then. But
Okay.
thank you so much.
It's my pleasure. All right.
Thank you.
Good to see you all.
Thanks, Mike.
Appreciate you. Thank you.
Bye. Take care, Tom.
All right. And with that, I will pass it back to you, Jen, once I get to Sharon.
So it looks like our next item agenda is an update from CROG.
All right. And for the sake of time, we will go through these fairly briefly. It's presenting, right? Is it
Yes.
shown? Okay, cool. So I'll pass it to you, Caitlin. I think you're the first one going, or
Sure, this is pretty self-explanatory, and you might not necessarily have noticed this just because we do the bulk of our emails through Constant Contact. But we are now not crog.org, we are crogct.gov. Go us. So just be aware, especially I think if you're emailing us individually, we have heard some pretty like some more intense spam filters have been catching some of our new emails. And that also is our website as well. We're now crogct.gov website as well. But don't worry about it. It shouldn't really affect you from the outside, but I did want to let you know.
all right. And I'll pass it to Heidi.
All right. Good evening, everyone. We have 2 workshops coming up this fall as part of our regional housing strategy. One is September 24th in Southington, and the other is October 16th in East Hartford. I want to see at least one Planning and Zoning Commission member from every municipality to try to attend one of these meetings. I've shared this flyer with your planners and also asked them to start distributing. So we hope you can attend one of them. It's the same meeting twice, so we're just asking you to come to one. If you have any questions, just contact me. Otherwise, we hope you'll register.
All right, and now to Kyle.
Had to unmute myself. Hello, everyone. Just a quick update on our regional warehousing study. We are looking at the land use and traffic patterns associated with these large-scale e-commerce and logistics proposals, mostly focusing on the 9184 corridor. We're about halfway through the study, and it's been. I knew it was going to be an interesting study, but it's exceeded my expectations in terms of the findings that we've generated so far. So that what we've completed so far is a market analysis and market projections for the sector for the next 5 to 15 years. We've done some traffic counts, which has been interesting in terms of the data generated. We've actually kind of ground truthed a lot of assumptions about the traffic generated by these types of developments. And we also have a last mile analysis dashboard available on our website, and I'll drop a link in the chat. But if you have any further questions or want to get engaged with that study, just feel free to reach out to me. My email is down in the right-hand corner. And that's it. Thanks.
All right, and finally, I'll share this. Feel free to scan the QR code if you want to get access to the paper, but I can share a link in the chat. We just recently finished a place's topical report that kind of runs through a few things. What is a third place? And I have a brief description there on the slide. But it also goes through the benefits of third places for social well-being, outlines why we kind of are focusing on this, one of the main reasons being the loneliness epidemic, and then presented tiered solutions to support existing and invite new third places to the region. Part of this was so that we can look to diversify land use. We have a persistent or at least the reason why I enjoy looking at this stuff is because we have a persistent youth retention issue here in the region, and a lot of the times we talk about jobs and housing, but I constantly hear from my friends and then just folks that we know that are young professionals who have moved away, that the main reason why we are moving away is because it's too boring. So a big focus on this is how do we get more things to do here? When we were doing the POCD outreach, that was a big thing that we were hearing while we were tabling as well. And so this kind of goes into how we can diversify a little bit of land while still respecting neighborhood context, but also how we can kind of bolster the places that we would typically see third places like our downtowns and town centers. So that's that. I'll share a link in the chat once I'm done presenting. And if anyone's interested further, please reach out to me. Okay, and go for it, Jen.
Okay, we have the report on zoning and subdivision referrals.
Okay, so I'll go through this really briefly, not too much to present here. I kind of held on to these as long as I could to present to you guys, but nothing was really coming through that was really flagging any regional significance. We had a few comprehensive rewrites. One of note was Vernon's, where they it seems like they were allowing more uses and more zones. Specifically, I saw an increase in multifamily housing. Specifically two-family dwellings were being allowed in more traditionally single-family residential zones, which is great to see, especially because those can just seamlessly be blended in through design standards. So that was great. One thing I did want to note as well is for the most part, I am receiving, just as an example, Windsor is sending me every single revision to a specific referral that we've received. And unless it's extremely drastic of a revision, we typically don't need to see those. Still send the revision, but more along the lines of also with that revision, let me know if you need a new comment letter. Otherwise, the comment's going to stay the same, so we don't necessarily need to reissue one. Okay, so that's that. I have a few more on this side, but again, nothing too much of note. Blah, blah, blah. Yeah, more just housekeeping issues, and then a specific development in Farmington needed a map change, but it was for a more enclosed development, so it wasn't going to be affecting any surrounding areas too much. And that's that. So with that, pass it back to you, Jen, to handle the kind of fun stuff.
All right, so at this point, we'll go around, and if anyone has anything to share about what's new happening in their town, we can do that at this point. I can tell you that in Plainville, we have several businesses along 372 that are up and coming, including a Russell Speeders car wash, a Doro Marketplace, and a Chipotle. We have another chunk of land that's next to that there is looking to continue with developing. And it's interesting because this is a larger set of parcels that developers had come to us several years ago looking to develop and to try to manage a lot of the on-site movement between the businesses without adding too many curb cuts because it's a state highway. And it took quite some time. Maybe it was the market, maybe it was COVID that had an impact on that, but all of a sudden this chunk of land seems to be taking off. We're also seeing a surge in planned development district applications, which, that it's so unique to see what developers are coming up with to put together for reuse for some of our parcels of land, because we don't have a ton of vacant land in Plainville. So yeah, it's exciting to see what's up and coming. Who else would like to share? Does anyone have anything interesting going on in their town? Not seeing any hands.
Or challenges or questions you want to poll the group on. This is another good opportunity for that.
So I stumbled upon something interesting. One of my clients lives in West Hartford. She's in, I would say, her early 80s and had been in kind of a transplant to West Hartford, relocated there, a little bit older in life. And one of the things she had said to me was that when she entered that community, she felt like she was kind of an outsider. And it was very difficult to meet people, to get, to mingle and to feel a sense of belonging. So she happened to use social media to try to reach out to see if there were other people that felt as she did. And she started getting a lot of responses from others that felt the same way, because, some families had been there for many decades. And so, through different school events, from kids through church, they had good social networks and a lot of friendships. So she actually started meeting with people and a group where people would get together and go out to lunch or go for a walk or do different activities. And that has been going on for many years. And I'm almost wondering, to follow up with what you had presented on, Jacob, where, we're looking for these in different towns and larger cities. We're looking for social areas where people can find a sense of belonging and a sense of mingling, where there's activities that will engage people and bring them together so they feel supported. We went through that period of time during COVID where there was such isolation, and technology has become such a big part of our lives for communication, especially with our younger people, where everything went from, pen and paper to a classroom presentation to a whiteboard, and now everybody's on Chromebooks and everything is very technology oriented. But I think, it's technology is definitely a way that is current and more people are comfortable with it, but it's a way to reach out to people through different social mediums to bring people together so they do have that interaction and sense of belonging. I'm almost wondering if, as we are adding things to our towns, if there's more sponsorship for opportunities for people to mingle and to meet and to feel more of that sense of belonging versus them, struggling on their own and not feeling as supported, which, may leave them feeling this may not be the town for me.
Yeah, I think you bring up a good point. Technology is a good thing and a bad thing in this context because while it might offer the opportunity for folks to reach out to one another and find a sense of identity or shared identity on platforms that weren't otherwise accessible, because they would have to go physically go find that. It also poses the threat of being able to find that social escape by just staying at home. And what that does is it takes feet off the ground and out of our centers and things like that. So I think in the paper that when we discuss this kind of stuff, we put a focus on making places that really do naturally invite people to come out, making those so accessible and so open that it's just naturally, it's almost easier to go do that than just sit on your phone at home. So if we kind of counteract this like digital age with accessibility and affordability and all those things when it comes to social spaces, I think we would naturally see more people being able to go find people and go out. To get to your point of kind of this, you're an outsider in the neighborhood, I think we also discuss this in the paper. Um, Social media and technology exacerbated a problem that was already existing. So when I'm thinking about my own family, they live in Newington, they live in a cul-de-sac. Their options for friends are Lisa across the street who already has her clique and Phil down the road who like doesn't want anything to do with nobody. And when you are left with those people as your options for friends, what do? It's already hard enough making friends as an adult, but now you're kind of stuck in this little pocket community that really everyone already knows what they're doing. So I think the solution is a pronged approach, but the first one is making sure that we have enough spaces for people to feel comfortable. My dad's an awkward dude, and he has a hard time walking into a space and just being able to be social. So making sure that these places are comfortable and the conversation is already happening, already flowing. There are people already talking to allow him to feel invited in these situations. And the other one is to provide housing so that those spots all have consistent foot traffic. I'm thinking a decent amount of our downtowns don't really have a lot of housing in them, unless you're talking about Hartford or West Hartford, different areas like that. Manchester's kind of working on it. Um, but if we don't have enough foot traffic to already fill these places so that people can think, oh, I can consistently and reliably find other people to socialize here, and that's just a natural instinct that they can go find that, it's going to be a little difficult. So by providing that housing in those little areas that where these places are, you not only offer the opportunity for people to have a high amenity living experience, you also offer business support and economic support for those businesses to thrive and be able to expand and exist there longer term. You offer the opportunity for people to be able to go socialize. But most importantly, you offer more kinds of people. So instead of just Lisa and Phil as your options, you know how like have X, Y, and Z, Dave, Chris, and Matt to be buddies with. So the more people that we invite into these spaces, you don't have to go crazy and become Manhattan, but just raising the bar in terms of the amount of people who are there and offering different kinds of housing so that you're getting different kinds of people. It really does help things out, not just for businesses, not just for people like my dad, but for our sense of community and the sense of belonging. Um, it offers more opportunity for less clicks and things like that. So that's my preach. But that's kind of what this paper offers, and it's just the kind of surface level. And we intend, I think, to dive a little bit further. And we want to help you guys along the way if you're interested in that stuff.
Yeah, Jen, I would add, I wrote the paper with Jacob. Jacob and I co-wrote it. Towards the end of the paper, we have some specific suggestions on how commissions can kind of take the next step. So like it ranges, there's three different options. One is just have the conversations. What are the kind of questions you can ask as commissions, like in terms of like, are we are we encouraging the type of activities and land uses that we want, or is there something in our regulations that are preventing this? So towards the end of the report, we have some actionable items that you could take. And if you want to follow up that conversation, Jacob, but I would absolutely love to talk to any of you if you want to follow up on the report a little further.
Thanks, both of you.
Of course. Yeah, Lisa, your hand?
Yeah, I just had a quick question. I didn't look obviously at the third place as the whole report, but I thank you for the comments and I really like the idea that you want to share some questions for commissions to be thinking about. And two places come to mind, and I in a quick preview of the report, I didn't see them, but Gastro Pub in West Hartford and Parkville Market in Hartford. So the idea of bringing a number of commercial establishments together under one roof, but creating all of that community seating, is going beyond just the coffee shop. I know you were just talking about housing, but in terms of, places to gather, I'm with the Avon Planning and Zoning Commission, and I'm very excited because First and Last Tavern was recently sold to, as many of you know, the Dobbs coffee shop owner. And so when I think about, I know people are talking about what they want to see there. Rather than a single restaurant or a single place, is there a way that we can create more places or more opportunities for people to come together, like Parkville Market? And I know there are some, I actually don't know how many changes, if any, would have to be made to our regulations, but I was just wondering if you explored that all in the third report, which I plan to distribute to the commission. So thank you.
Yeah. So I think we went into it a little bit, but for the sake of brevity for the report, we took some of those more exploratory spaces out of the report. That being said, I am tasked with doing a zoning audit or a third place audit for zoning, and one of my task in my own outline is to look at Parkville Market and Gastro Park to specifically see what kind of zoning allows for that stuff. Because you're totally right. The rentable kind of model for different, uh, uh, just multiple different folks to come in and be able to start their businesses in there, just provide the space for that to happen is definitely something we're interested in. It's a good model that we have currently. So, it's not going over our heads for sure.
Okay, great. Thank you.
Thank you. All right. Any other questions regarding anything, or could be any of the things we presented on, or anything else that is going on in your towns? Going once, going twice. Okie dokie. With that, I'm just going to quickly share. Oops, I just created an extra slide for no reason. I'm going to quickly share the last slide, Jen, if you don't mind, but it's just other business. And just going through this really quickly, there's just some clear trainings, commissioner trainings. Obviously, we'll send around a certification email for this specific training, but in addition to this, I also included in your emails for this meeting different registration links for these specific clear trainings as well. So if you're interested or need any of those links to be sent around again, please feel free to reach out to me. I will also include those links again when I send around the minutes next week. But if you need anything else, let me know regarding these. Okie dokie. And with that, that is it. So I'll pass it back to you, Jen.
Thank you. Sounds good. Great information. The trainings are always very informative. So hopefully a lot of the commissioners can attend because it always helps us be better commissioners. If no one else has any other questions, would someone like to make a motion to adjourn?
So
So-
moved.
Second, Bolton.
Any, Any further comments or discussion? Hearing none. All those in favor signify by saying aye. Aye.
Aye.
Aye.
Any opposed? Any abstentions? Motion carries. Everyone have a wonderful couple of months, and we will see you again soon.
Thank you so
Thank you.
much,
Thank you,
everyone.
guys.
Thank you
Take
again,
care,
Mike.
everyone.
Yeah.
Great conversation.
I just realized that my screen was buffering and that slide never shared. I was
Never
talking to
showed up.
myself. Oh,
It's okay. We will be sharing them out.
yeah.
Good
Okay.
night, everyone.
Good night.